I've given a lot of consideration to it since Monday. I suppose the argument that we had in the House, or the debate, was very good and lots of food for thought. And a few things I considered around it. And that was that, in the first instance, for journalistic practice, we're dealing with professionals, and we're dealing with people who come through a college and are taught about defamation. They're taught about, the legal limitations to the practice of their art and their skill, and in so doing, this will be part of it, and it will also be I suppose, a significant event in halting the transparency or the ability of journalists to name victims of crime, and of a particularly horrific, the ultimate of homicide. And so, in that regard, I have full faith in their training, and I have full faith also in the fact that the Law Reform Commission published consolidated legislation. So anyone who is bound by law in the practice of their profession generally has an awareness of that. So we're not dealing with, Joe Smith on the street. We're dealing with people who they're the very act of carrying out their job has legal implications that they need to be aware of, and I believe that will happen on that occurrence. So as a result, I think that we're dealing with the same text, just laid out under different numbering, and so I would support the Minister's resistance to that, because I think that the amendments are very clearly inserted where they should be, and that any other texts, any other issuances of either the Department of Children or the Department of Justice, anything that supports this now does not have to be amended, because the reference numbers are all going to be the same. So I think that there's a coherence there that makes sense to me. On the issue of the other child, I've come back between Section 2 and Section 2A. I've gone backwards and forwards between that and seeing what I see is an entitlement of incremental dispensing of this prohibition, and in Section 2, which is qualified by 2A, but not prohibitive. So there is, as long as the judge gives their determination in the public court as to why they've made the decision they have, because there's a further section that obliges that, then it can be an incremental. So it can be to limit the naming of a child witness while still permitting the naming of the child victim. So I think that is found and contained within Section 2, coherently within the Act and within the ministers and the government's amendments to it. So in that regard, I think that this will be all right. I think that it makes sense, and that there is a proper qualification in there that, to me, that I'm comfortable with.
Thank you.